Good morning, everyone. I just want to give everybody a few extra minutes to join in before we get started. So again, we're going to go ahead and give them just a minute or so. My name is Greg Roop. I'm actually working with CDMS out of our Long Beach office. I've put my contact information up there as well as our general mailbox and phone number. Um, I have this again at the end of the presentation. So if you don't write it down now and you have some questions for me when we're done, or if there's anything CDMS can help you with, please feel free to reach out to us. So for today, what we're going to do is we're going to go over historical perspective of workplace violence in California. We're going to do some definitions of the rulemaking process so everybody gets an understanding of what it is that they need to prepare. We're going to go through the 12 steps of the written plan and then the additional requirements of the program itself, which includes the training and any kind of record keeping requirements. So when we look at workplace violence in the regulations, most of you know that California has its own Cal OSHA branch, which is a state plan. There's a federal OSHA plan as well. And workplace violence has historically been part of the general industry clause or the general duty clause, which states that all employers provide a work environment free from recognized hazards that are causing or likely to cause death or serious physical harm. California, back in 1973, adopted Labor Code subsection 6400, which is very similar, but in a California way. It says that it provides that employers are required to furnish employment and a place of employment that is safe and healthful for the employees therein. Now, as part of that, Title VIII was created, and Title VIII has within it other programs which you're probably familiar with. And so for today, I would really like you to pay special attention to Title VIII, subsection 3203, which is known as the Injury, Illness, and Prevention Program. It's also called IIPP. I'll be using it throughout the day because this workplace violence plan was modeled after that plan. And since 1991, your company, if you've had to have an IIPP, most likely are going to need to have a workplace violence prevention program. Also, Title VIII 3220, the Emergency Action Plan. If you have one of those, have it out in front of you as well as you're preparing your workplace violence plan. We call this the Evacuation Plan, Fire Drill Plan, but the real name is called the Emergency Action Plan. And then finally, there's already a workplace violence prevention plan out there. It's been in the law since 2017, and it's for healthcare employees. Now, I want to state that the healthcare plan itself is very narrow in its scope. It really applies to traditional healthcare facilities like hospitals, skilled nursing facilities, emergency rooms, some rehab centers. It excludes a lot of other types of medical operations, such as pharmacies, chiropractic offices, some types of rehab centers. So if you're not part of a traditional healthcare plan, then you're most likely going to need to have a workplace violence prevention plan. When Senate Bill 553 was signed, it became part of California Labor Code in that 6400 section. It's now referred to as 6401.9. I'm going to be making references to that through today as well. So let's talk a little bit about the history of workplace violence. So beginning, actually the last year that we've had statistics, roughly one person a week in California died at the hands of another while working in California. About a third of those worked in retail or food service. At the national level, almost half of the non-fatal workplace violence was committed completely by strangers. These are important things to consider as we're developing the plans for your company. And about 8 out of 10 of the offenders were unarmed. And of the 16% of cases where a weapon was confirmed, 6% used a knife, 5% used a firearm, and 4% used something else. So let's talk about what Senate Bill 553 is. If you guys remember your Schoolhouse Rock cartoons from Saturday mornings. A bill is created by either members of the Senate or the Assembly in California, where it goes to the governor for signature and it becomes the law. So on September 30th of last year, Gavin Newsom signed Senate Bill 553, along with, I think, 31 other bills that were in front of him that day. The enforcement of Senate Bill 553, the enforcement of the law starts on July 1st, so less than 2 months from today. Cal OSHA has been given the enforcement responsibility, and Cal OSHA has said that there is no grace period for enforcement. Now, what's really peculiar about this is a few things. If you read the letter that Gavin Newsom sent out, he didn't send this to the press. He didn't send this to business owners. He sent it to members of the Senate. And there are references in there to workplace violence in and around retail theft. It's really important to remember that this requirement for 553 goes well beyond retail and violent crime and smash and grab robberies and so forth. It was also very unusual that 2 days before that, he signed Assembly Bill 1228, and that got a lot of press. That was the bill that provided a minimum wage for fast food workers of $20 an hour. So he did a press release for that. A lot of people chimed in, made the news. You probably remember that. But 2 days later, he signed this bill, again, along with a bunch of others, and I can't find a single press release on it specific to Senate Bill 553. So if you're just hearing about this for the first time, or you've just started hearing about it recently, you're not alone. A lot of our clients haven't had any familiarity with that. I don't think there was an expectation to. It was just one of those things that was passed quietly. But the obligations now have been shifted to the businesses to create a program that would accommodate this. So let's talk a little bit about the difference between the plan and the program. So I'd mentioned the injury, illness, and prevention program earlier. With a workplace violence prevention plan, you can make that part of your IIPP. As a matter of fact, if you look at the requirements for workplace violence, it's almost exactly verbatim to an IIPP. If you open 2 tabs on your browser and you bring up the requirements for one on one tab and the requirements for the other on the other, you're going to see a lot of similarities. All right. There are a few differences, and we'll go through those today. Now, the plan itself must be established, implemented, and maintained. That's actually a legal term to bring something into existence, to put it into effect, and to keep it in good condition by reviewing, repairing, and updating it regularly. That's really, really important to consider. The program part of it also includes a record of workplace violence hazard investigations and the evaluations and corrective actions of those workplace hazards, any violent incident logs, and that it may impact other reporting, which we'll talk about, record keeping, and then the training requirements. So Senate Bill 553 was signed into law, but again, if you remember Schoolhouse Rock, once it becomes the law, it needs to be adopted into a standard. So a standard is what Cal OSHA would consider regulation. So if you look in Title 8 of the California Code of Regulations, which is probably where you're going to find this, you were going to find a standard. And a standard has to be developed by Cal OSHA and then has to be approved. And it's those standards that are enforced. So the timeline for this, it's been signed into law, but there's still not a standard yet. This is why we're still talking about it without a number. We're calling it 553 or 6401.9. But I anticipate at some point it's going to be Title 8, CCR, subsection, I don't know, 3225 or something. But for now, Cal OSHA has until the end of till the end of 2025 to propose the standards for 553, and then they have to submit those to the Occupational Safety and Health Standards Board, and they have up to a year before they adopt the general industry standard. Now, this may be a little difficult to do. As of today, there is no director in Sacramento for the Director of Safety and Health. That position is vacant, as is the executive director position for the board. So We'll see how this happens. They have up to 2 years. I'm not saying it's going to take that long. They may get this done in a hurry, but that is what the timeline that's been given in front of them. So you're probably asking yourselves, well, how is it then they're going to enforce something which really hasn't been written yet for the next 2 years? The answer to that is I called Cal OSHA. I said, what are you guys going to do? And they said, well, they can only write citations really against the IIPP, the 3203. They can't write any citations against the new requirements of workplace violence. So let's just take a breath. And before we go any further, I'm going to survey everybody and ask yourselves, well, do you need to be here today? Is your operation part of this workplace violence prevention plan? 4 basic questions I'll ask you. Is your company already covered by the healthcare standard, which is 3342? Chances are, if you're a client of CDMS's, you're not covered under that. Do your employees telecommute from a location outside of your control? Do you have a completely remote sales force? There's no way the employer could be accountable or have a duty to provide safety for those employees. Probably not. Is your location closed to the public where fewer than 10 employees work at any given time? I stuck an asterisk there. And is your company a law enforcement agency or a correctional facility? Again, if you're a CDMS client, probably not. The part about being closed to the public is already causing a lot of questions during the rulemaking process because it's really difficult to find a business that's truly closed to the public. And that closed to the public might mean taking deliveries or having vendors come in, or occasionally a client will pick up an order at the loading dock. So again, would those companies qualify? And I think for right now, they do not. All right, you ready to get into the plan? We start looking, and there's 12 parts of the plan. I'm not going to read all of these slides to you, or these next 2 slides to you. We're going to go through each one of them. I want you to pay special attention to the words effective, effectively, and effectiveness. As you sit down to write your own plan, and you're going to use a whiteboard, put it up on the wall, I want you to write those 3 words with a Sharpie. We're going to talk about them a lot today. It's a really, really important part of what you do because it's what OSHA is going to be judging you against. Again, 12 steps to do it, and we're going to walk through on how to do each one of these. So the reason I highlighted effective, this is a screenshot directly from the Cal OSHA website. It is a list of the most cited violations that they've handed out year after year. You'll see that, again, we talk about the Injury, Illness, and Prevention Program, 3203. And if you look down to, you'll see the one Injury and Illness Prevention for Construction, its sister. You can go onto this website and you can click on each of these violations. And normally what happens is if there's an incident at the work site and OSHA is called out to investigate, they'll show up, they'll do their investigation, and they'll ask why the employee got hurt or what happened. And if they had an IIPP in the first place and the worker was doing something against what the employee handbook said they needed to be doing, they would get an additional violation for an ineffective IIPP. If an OSHA investigator shows up at the site and they interview workers, even the workers that aren't hurt, and they say, do you receive training for your IIPP? And the answer is yes, but they can't really demonstrate anything else. Or if they say, do you know where to find your IIPP? Or do you know where to go in case of an emergency? If the employees can't answer that in the affirmative, then they might get a citation for an ineffective IIPP. It's a very subjective, almost up to each investigator. But again, year after year, as far back as you can find on the internet, and you look at some of these violations, and some of these were very, very serious accidents. And so there might be, hundreds of thousands of dollars in fines. And then on top of that, they get a violation for an ineffective IIPP. So because this Workplace Violence Prevention Plan was modeled after the IIPP. This is the opportunity for you as you're developing your plan to make sure that you use effective measures when you create it. Use effective training protocols, use effective record keeping. Very, very important. This is why I say write this word in Sharpie, and I want you to consider this as you develop your plans moving forward. All right, let's get into the actual plan itself. First thing you need to do is you need to provide the name or the job titles of those responsible for implementing the plan. And let me just take a step back. You can write all this down, or you can go on the Cal OSHA website. They provide a template that has all of the same information, but not as much detail. If you are going to use that template, they also have a disclaimer in there that the template itself does not meet the requirements. Again, first of all, this standard hasn't been created yet, and it just barely covers the topics to discuss. So it says right on there, it doesn't even meet the standards of 6401.9, but at least it'll give you something to start working with. So we need to start this with naming somebody or a group of people with the job titles and those responsible for implementing the plan. That could be very similar to your workplace. I mean, your IIPP. It could be your human resources person, your general manager, your site lead. I always recommend doing this via committee. If you have more than one people, or I'm sorry, more than one person in this group, then you need to identify the steps or the responsibilities that each one of those has. For instance, if one person's responsibility is to write the SOPs, then that needs to be there. If one person has a responsibility to do the investigations, one person has a responsibility of receiving the reports, whatever that may be, it has to be identified and it has to be clear so people know where to go for different things. Number two, the employer's procedures to obtain the active involvement of employee and authorized employee representatives in developing and implementing the workplace violence prevention plan. Again, you can do this via committee, a safety committee. If you are at a site that has union representative or other vendors, then you need to have them as part of the decision-making process. It's a very important consideration. This information is also part of an IIPP. You need to develop methods that the employer will use to coordinate implementation of the plan with other employers. Again, this would include any labor unions, staffing agencies, and potentially vendors. Everybody that's on your work site is part of this plan. So temporary workforce, I know a lot of clients will use even seasonal employees. They need to be trained on the plan. They need to know their responsibilities and the rights under the plan. So again, keep everybody in mind when you create this. Must have effective procedures on how, again, the word effective, right? Effective procedures on how to accept and respond to reports of workplace violence, including procedures to prohibit retaliation against employees reporting workplace violence. There's an awful lot to unpack with this one. So again, does your organization already have this as part of your injury, illness, and prevention plan? Is it part of your emergency action plan? Now, your emergency action plan, again, that's the fire drill plan, but there should be steps in there, what to do in the event of an emergency. Do you use a series of alarms? Do you have a muster area where everybody gathers? Who does the reporting? Who calls 911? Again, if you're creating a plan like this for workplace violence, you want to make sure that your plans aren't contradictory to one another, and you want to make sure it's really clear. So I recommend that you adopt the same procedures if you have one point of contact, etc. Do you have a whistleblower provision in your policies? Again, this requirement says that you cannot retaliate against employees for reporting hazards or threats. So it's really important that you cannot retaliate against them. And, you know, this is one of those requirements that intersects with a lot of other California Department of Labor requirements. So I recommend you coordinate with your human resource department and make sure that whatever plans you're putting together are lawful. You need procedures to effectively communicate elements of the plan with employees with regard to workplace violence matters. Now, the IIPP equivalent of this is the one that seems to get a lot of employers. They they're not trained as often as they should be. They're not sure what to do. They're not sure the elements of the IIPP. So, in regards to workplace violence, this is your opportunity to get it right. This is where they've added the word effectively. You got to figure out if this is going to be a standalone policy or part of an IIPP. Now, there's advantages to combining them and there's disadvantages to combining them. Those would be if you're going to do it as part of your IIPP, a lot of this is already there. You just have to add the workplace violence components. You have to identify the risks and the hazards. But an IIPP is not required to be trained annually. It's recommended to be reviewed, revised as needed, but workplace violence, it is a requirement that you have to train the whole plan annually. So by combining it with an existing plan, it may increase your training requirements to your staff. You can need to keep all your records of training and documentation and communications regarding training for at least a year. Again, note effectively. More effective procedures to ensure that all employees, supervisory and non-supervisory, comply with the plan. A lot of people get into the mistake of creating an employee handbook and they just say, these are all the rules that you need to follow when you work here. This is our policy on sexual harassment. This is our policy on cell phone use. This is our policy on dress code. And then the employees might sign off on that document, send it back to you. You say that they understand the rules and the requirements. But in terms of workplace violence, this is not enough. That alone is not enough. There also has to be a way to gauge the compliance, again, of the supervisory and non-supervisory staff. And that's often done with disciplinary action. So if you have a policy in your handbook that says if you break the rules, then this is what happens the first time, this is what happens the second time, this is what happens the third time. Again, I expect this to be a future target as it has been with IIPPs. So pay special attention at number 6 as you're developing your own plan. Effective procedures to respond to actual or potential violence workplace emergencies. All right, there's a lot going on with this one too. Does your organization, as part of your other plans, do they have a team to respond to emergencies, or is there a single point of contact? What is your policy, fight or flight? An example of this would be if you've ever done any kind of active shooting drills. You may have a program to where if there is an active shooter, step number 1 is to get away from the threat. Step number 2, if that's not possible, would be to shelter in place. Step number 3, if those first 2 aren't available, is to fight back. Well, if you're, asking your employees to fight back, what tools do they have at their disposal to fight back? Does your employee handbook look like a TSA prohibited list? Do you prohibit any kind of weapons, guns, knives, pepper spray, stun guns, anything like that at the workplace? If so, what tools are going to be made available to the employees? There's actually some consultants out there that are recommending self-defense training to address number 7 here as an effective. Again, we're trying to prevent workplace violence. So self-defense, de-escalation training, those types of tools may be beneficial depending on your operation. Do you have more than one shift? So if you've got a point of contact to respond to emergencies, but they only work days, what do you do if something happens on your second shift, or maybe you come in with a skeleton crew on the weekends? Make sure that whatever your policy is, whatever your plans are to respond, and I'm talking about real-time threats. Somebody's in your lobby, somebody's at your loading dock, something's going on. What are the employees' instructions? Be very, very careful. Employees in California, all people in California have the right to defend themselves. It is a castle doctrine state as well as a stand your ground state. So if you're writing policies, keep that in mind, okay? And again, does your organization already address this with your IIPP, your emergency action plan, or in some cases, a business continuity plan? We need to have procedures to develop and provide training. Again, how does your organization train employees for other programs? If you are a type of organization that creates tests or online content, or you maybe use a SharePoint, or you may purchase videos for your employees, all great methods. Just keep in mind that with workplace violence in particular, there has to be an interactive portion for the training. That doesn't necessarily have to be in real time. It doesn't even have to be somebody on site. It just has to have a provision for somebody to ask questions with somebody knowledgeable of the plan. That could be a vendor, that could be somebody internally. It might not even be somebody that's part of your workplace violence prevention committee. But as you're developing your training program, keep that in mind as well. Procedures to identify and evaluate workplace violence hazards. Now, this one is probably the one that's going to be the most time consuming. So depending on your organization, and just like your IIPP, where you needed to kind of outline all of the different job types to prevent workplace injuries, this one is similar in that you have to try to find the risks associated with your business. And again, what tools are you going to need to identify the risks? One advantage of having a committee put this together is the risks to somebody sitting in the reception office is probably very different than the risks that your drivers may have, or different than the warehouse workers or somebody in operations or your sales team. So, getting everybody's input and looking at what is the likelihood of, some sort of violent behavior altercation, again, based on your industry, and look at your historicals. What's happened in the past? Has anybody ever been attacked in the past? Have you been robbed in the past? Things like that. Procedures to correct workplace violence hazards identified and evaluated. So once you've identified all the different types of risks that are in front of you, again, you've got this whiteboard and you've gotten input from everybody on your team, and you're filling in all the blanks. Well, now what do you do with that information? Because some of these risks might be correctable with engineering controls. Some may be correctable with administrative controls. The difference in those engineering controls are going to be any kind of barrier that you put yourself, or that goes between the threat and the employees. So, a locked gate, a locked front door, access only buildings, security systems. Administrative controls are, do you change your policies? Do you make it so nobody walks to their car at night unescorted? Do you have other administrative controls to put different types of responsibilities on your staff? Those are typically not as expensive as engineering controls. But once you've identified these, how does your organization handle the actual capital expenditure to make this happen? If you've identified that, you need a perimeter fence, you need new security cameras, maybe you need to hire a security guard. How do you handle that, right? So how do you prepare a document to show an OSHA investigator says, listen, we've evaluated all this, and this is what we plan to do. We've identified this as being the most significant risk, so we're going to handle it first. This is a very expensive risk for us to mitigate, so we need to put it into next year's budget to get this corrected, but we're aware of it. So that's an important part of it, is to show your intent on what you plan to do. Procedures for post-incident responses and investigation. These are kind of the next day, what happened. Do you get the whole team together and review the logs? Again, you're going to need to have a response. And you have a duty to do an investigation. So what happens? You get the team together, you go through them, find out if whatever emergency fixes you need to develop for your organization, any logs of any of those things are going to be a part of it. And then finally, procedures to review the effectiveness of the plan and review it as needed. This is where a lot of people fail with IIPPs. They have a plan, it's in a binder, it's sitting on a shelf, and they don't look at it often enough. And new things happen, new risks come into the organization, new pieces of equipment show up. And again, how to handle that, right? You need to look at the effectiveness. And there are examples on the Cal OSHA website on how you measure effectiveness of your current plans. Just by virtue of something not repeating itself isn't considered effective. But again, keeping all those records, getting together, discussing it, and coming up with a plan. So all of those things, all 12 of those steps, what we've talked about, we put on these next 7 little boxes here. First thing you want to do is assign the responsibility. Second thing you want to do is to create a committee, which is my recommendation. There's no requirement to have a committee, but after the responsibility is assigned, you need to do a hazard assessment for everything within your organization where there is a risk. Next thing you want to do is you want to take that information and you want to create the written plan. As the 12-step plan, you need to have, and again, you can use the template that's on the Cal OSHA website, or you can use a vendor to help you with that. And then the training, you need to train the plan. Everybody in the organization, it's again, supervisory, non-supervisory, ownership, everybody has to be trained. And then after that, you need to review and revise as needed and train annually. Now, what's really peculiar here is, I mentioned this early on, is the bill is been signed. It's now law. It's now part of the Department of Labor Code. We know that it doesn't have a Title VIII code assigned to it yet, but we're going to have to review this at some point anyhow, because there are going to be changes. The way the plan stands now versus the finalized plan is probably going to be pretty different. There's certain parts of this that I think really need to be modified, and I'm not sure which ones are, and it's during the comment period. So if you have any input you want to share with Cal OSHA, now is the time to do it. But we'll go through that in the next few slides. All right, so that's the 12 steps. That's the plan. You're done with the plan part. What else do you got to do to have this? Well, you got to have the documents that make up the program. Most important one is the violent incident log. Employer shall, and when I capitalize it, that means it's non-negotiable. Any of your organizations that's ever had a ISO program or anything like that, whenever you see a shall statement, you should kind of recoil and say, all right, there's no getting around this. This is something they're going to look for. An employer shall record information in a violent incident log for every workplace violent incident. I'm going to stop for a minute here, and I'm going to just ask yourself to do this exercise with me. I'm in the Long Beach office. I'm in Southern California, and for the last month, I have been looking at everything I see on the news through the lens of I was their supervisor, and am I going to have to put this in a log, or what do I do? And by that, I mean, we've all seen the news reports of jewelry stores smash and grab robberies. We've all seen that. We've probably in the last few weeks seen a lot of the unrest happening on our college campuses, protests among students and outsiders with security brought in. Something crazy happened on the news here in LA last week. A transient picked a fight with a bus driver, and it spilled out in the street, and they're punching each other and whatnot. And I'm thinking to myself, how would I write these things up? What would be on a violent incident log? If I was the supervisor of the security team at the college, or if I was the supervisor of that jewelry store, or I was the supervisor of that Dash bus driver, how would I write this up? So again, an employer shall record information on a violent incident log for every workplace violence incident. The log shall include, at a minimum, the following information: the date, time, and location of the incident, all right? The classification, which is called the violence type, and I'm going to get into that a little bit, of who committed the violence. Classification of circumstances at the time of the incident. The classification of where the incident occurred. The type of incident, any consequences of the incident, and information of the employee or employee representative who completed the violent incident log. Do you know what's missing? Whoever it was that was assaulted, or any information whatsoever about who reported the violent incident. And that's by design. So it is forbidden to have an employee's name on the violent incident log. It's prohibited to have their email address or any other identifiers, their social security number, initials, anything that somebody could figure out who it was that was offended. You can, my understanding is you can, if you have a unique employer identification number that's known only to a very limited number of people within your organization. It's only known between you and the reporting person. That is allowed, as I understand it. But again, there's far more information about who's filling out the log than who's actually reporting the incident. So the next couple of slides is kind of what has everybody asking questions, right? So what do we consider workplace violence? Well, again, this Senate Bill 553 was turned into Labor Code Section 6401.9, and it now has a definition. Workplace violence is defined as any act of violence or threat of violence that occurs in a place of employment. This includes, but is not limited to, the following: the threat, notice the highlight, or use of physical force against the employee that results in or has a high likelihood of resulting in injury, psychological trauma, or stress, regardless of whether the employee sustains an injury. An incident involving a threat or use of a firearm or other dangerous weapon, including the use of common objects as weapons, regardless of whether the employee sustains an injury. Animal attacks are now included in Labor Code Section 6401.9, but they were not in the original language of Senate Bill 533. And the 4 types of workplace violence are defined in Labor Code 6401.9. Workplace violence does not include lawful acts of self-defense or the defense of others. Well, what is a threat of violence? Any verbal or written statement, including but not limited to texts, electronic messages, social media messages, or other online posts, or any behavioral or physical conduct that conveys an intent or that is reasonably perceived to convey an intent to cause physical harm or to place somebody in fear of physical harm, and that serves no legitimate purpose. I'll be curious to find out if this language makes it all the way to the final code. Again, I know why it was put in there. I'm not sure how organizations are going to patrol this. There's no duty for employers to monitor social media posts or text messages, anything like that. But I'm really curious how this one's going to get through the whole process. But it's something to consider. Now, I'd mentioned earlier about record keeping and so forth. And if there's active workplace violence, that results in an injury, okay? This is going to have to be logged on your violent incident log, and it still needs to be reported in your other reporting tools. We'll get to that too. But this definition here has got a lot of people puzzled. So let's talk about the 4 violence types. Everything's available online. You don't need to write these down. But type 1 violence is the workplace violence committed by a person who has no legitimate business at the work site and includes violent acts by anyone who enters the workplace with the intent to commit a crime. Now, this is the traditional, smash and grab robber. This is, hold up. This is, retailers will probably see this one a lot. I don't know so much about our clients, but perhaps. Type 2 violence is workplace violence directed at employees by customers, clients, patients, students, inmates, or visitors, or other individuals. All right, so again, we'll probably see this a lot in the service industries and the retail industries. But those examples I gave you earlier, the unrest at a college campus, and if a security guard was injured, would that be type 1 violence or would that be type 2? Was it a student that injured the security guard? Well, that would be type 2. But if it was an outside instigator that came onto the campus for the purpose of just creating a disturbance and committing a crime, well, my interpretation is type 1. Like I said, I've been doing this exercise for a month, and there's a lot of these that have me a bit confounded. Type 3 violence, workplace violence committed against an employee by a present or former employee, supervisor, or manager. I think a lot of us, when we came in here today, think that's probably the most common type of workplace violence, especially for professional industries such as ours. This is the one that seems to make the news the most. A disgruntled former employee comes back in. He's got a grudge. He was passed over for a raise. Whatever the case may be, that seems to get all the news. But statistically speaking, it's not as common as the media would have you believe. Finally, type 4 violence is similar. It's workplace violence committed in the workplace by someone who does not work there, but has or is known to have a personal relationship with an employee. Take a few minutes on this one. This one's obviously going to cover any kind of domestic situations at home. It's going to cover issues of stalking. It could be on site. It could be online. It could be somebody's waiting in the parking lot. There was something in my presentation earlier about no retaliation, and it's very important as you're developing the plan, you have to gain the trust of the employees to feel comfortable to come forth if they have information where they may feel threatened, especially at home. If there's a domestic situation at home and an employee comes to the responsible person and says, listen, things aren't going well at home. It may spill over into the workplace. I've cut off all communications with that person, but they know where I live. I just want to let you know, be prepared if this person shows up. I just want you to be prepared to respond. Again, you cannot retaliate against that employee. You cannot tell the employee, listen, you got to keep your private business at home. And if that comes here, then, your job's in jeopardy. That's not okay. So pay special attention to type 4. You need to gain the trust of the employees. You want them to come forward. Again, we're trying to prevent workplace violence. So, and that's all of your employees. And so keep a close eye on type 4. It's probably going to be a little more difficult at first, but you should ease into it. So what are the workplace violence training requirements? Well, you remember early on in the slide, I said when something needs to be implemented, established, maintained, and so forth, as soon as the plan is established, and then annually for all employees thereafter. It's right there in the law. That's how often you need to do it. So the moment you get this on paper, you need to start training. And that includes all employees. And it also, whenever you modify the plan or a new workplace hazard's identified. So let's say you've got your plan, you're pretty happy with it. But your committee meets once a quarter, and during the next quarterly meeting, you've identified a risk that you didn't identify when you set this plan up. Or Cal OSHA comes along and they modify this whole thing, and so they've identified risks for you or taken away risks that you thought were there. In any case, you need to retrain the plan again, specific to that workplace hazard. You don't need to train the whole plan. You just need to train the part that was recently identified. And again, I'm going to say this again, interactive training is required. There must be an opportunity for Q&A with somebody knowledgeable with the plan. It doesn't say in the law that has to be your HR person, the person responsible for the plan on site. It could be a vendor. It could be your corporate lawyer. It could be whoever you want it to be. But that is a requirement, and that does need to be part of the training record. And I guarantee Cal OSHA is going to ask for it. So record keeping, again, this is incredibly important. Everything not training related. So if we look at any type of violence incident logs, if we have police reports, if we have interviews, if we have any records of how the risk was corrected, all of those things must be kept for 5 years. If you've been filling out OSHA 300 summary reports, which I'm sure everybody does, and they post them between February and April, or if you were using your 50/20 form, which of course during COVID got really popular, that is also the same or similar document to your OSHA 301. That's a report of injury or illness at the workplace. All of these records need to be kept together, and they must be made available to Cal OSHA upon request. Again, 5 years, very, very important. The record keeping requirement for training, again, you need to do it upon hiring an employee. It doesn't say that you've got a day, a week, or a month. It just says upon hiring an employee. So it should make it part of your orientation process, as you do with some of your other materials. Anytime there's a job duty change. So if you promote somebody within your organization, or you move them, let's say from, I don't know, a driving position to a manufacturing location, anytime that there's a different type of risks, they need to be trained in those job duties. And again, annually, I'll keep saying this, annually. Training records also need to be kept for 1 year minimum. That's all sign-in sheets, individual training records. If you're providing tests to your employees, sign-in, any of those things, you need to keep those for at least a year. Finally, and my last slide for today, I'm not sure, I kind of touched on this briefly, but if you're part of any collective bargaining agreement after January 1st, 2025, it authorizes employees' collective bargaining representatives to seek a workplace violence restraining order on behalf of an employee and or other employee at the same workplace. All right, this is what I have for today. I'm just going to add a little bit of commentary in there for those of you that are looking to build a plan. A few words of caution. If you're going to use the internet, that's great. It's a great resource. It's also very, very confusing right now for a couple of reasons. One is there's a lot of outdated and incorrect information there. When 553 was first put together, there was some language in there that was struck before Gavin Newsom signed it. So make sure as you're writing your plan that you're following the most accurate information. And if you simply Google workplace violence prevention plan in California, you're probably going to see a lot of data related to healthcare in the 3342 plan. Don't fall into the trap. They're not the same. And it's real easy to start creating SOPs and around the wrong program. And check back often as you're creating the plan. Like I said, OSHA's got till the end of 2025 to really get things done. So as changes are made, make sure you stay up to speed on what's happening. Even when I was preparing today's presentation, I did find a lot of erroneous information. I had to fact check a lot of things. There's a lot of bad information out there. There's a lot of good information out there now. But it's not CDMS's position to take sides on this. It's our objective, as it has been since 1988, to keep our clients safe and legal and doing business in California. So again, if there's anything that we can do as CDMS, please feel free to reach out to us. Again, my contact information is there. That is our general phone number, and we'd be really happy to take your questions moving forward. Thank you, everybody. Have a great rest of your day.